session while we're in the BCC conference room upstairs prior to the lunch break. So we are back in regular session. Good afternoon, everyone. Thanks for being at Harris Hall today. It's the best place to be. There are no rivers you'd rather be sitting beside. There are no ball games you'd rather be at. This is the action. So today we have before us a third reading on Ordinance 1352 in the matter of amending the Rural Comprehensive Plan to add the subject 63-acre property to the Goal 5 inventory of significant mineral and aggregate sites. Amending the Rural Comprehensive Plan diagram to natural resources, mineral, and rezoning the subject property to sand and gravel rock products, SG, in accordance with OAR 660.023-1080, Lane Code 16.252, Lane Code 16.400, and Lane Code 12.050, Department File 509-PA 1605971. And today, Mr. Mokrajewski, I believe Mr. Rafael Saba is with us.
He's been here for the last hour. I stopped in while everyone else was getting a bite to eat, and Rafael was preparing for this item.
All right. So can we keep this under 3 hours? Okay, good.
Good afternoon, Chair, Commissioners. As you'll recall, on June 27th, the board conducted a public hearing and deliberated on this matter, this plan amendment to add the 63-acre property to the Goal 5 inventory and to amend the plan designation and change the zoning to sand and gravel. The board at that time voted unanimously to tentatively approve the application and directed staff to revise the findings to reference two submittals by the applicant. One was a noise study that addressed the OAR requirements for new noise sources, and the second was a letter that addressed water issues south of the river. The findings that are before the board today reflect and support the board's June 27th deliberations, and the planning director recommends approval as presented.
Thank you, Mr. Saba. I'll ask for discussion around the presentation. We have two alternatives: one, to adopt Ordinance PA 1352, or move to set a fourth reading. Discussion. I see none. Do I have a motion? Commissioner Bozevich.
So I'll move approval of Ordinance 1352 in the matter of amending the Rural Comprehensive Plan to add the subject 63-acre property to the Goal 5 inventory of significant mineral and aggregate sites, amending the Rural Comprehensive Plan diagram to natural resources, mineral and zoning, and rezoning the subject property to sand and gravel rock products SG in accordance with OAR 660.023-0180, Lane Code 16252, Lane Code 16400, and Lane Code 12-050.
Second.
Ordinance PA 1352 moved by Commissioner Bozevich, seconded by Commissioner Lyken. Discussion to the motion? I see none. Mr. Mokrajewski, this is an ordinance, so it will require a roll call vote.
Commissioner Sorensen?
Aye.
Commissioner Bozevich?
Aye.
Commissioner Lyken?
Aye.
Commissioner Williams?
Aye.
Commissioner Farr?
Aye. Passes unanimously. Thank you, Mr. Saba. You kept it under 3 hours. Beautiful.
Thank you.
Then we will move along to item 2 on today's agenda, this afternoon's agenda, excuse me. It's 13B. Actually, 13B has 3 different orders associated with it. We will take action on one of the orders. The other 2 will die for lack of action. So the 3 orders are, I'll just do the 07, 08, and 09. And 09 is at this point the staff recommendation. Mr. Mokrajewski, I'll allow you to introduce the panel and get us started.
Turn it over to Lydia.
Amber Bell is our associate planner who's managing this project. I'll let her do the presentation.
Good afternoon, Commissioners. The item before you, the board is asked to elect whether or not to conduct an on-the-record hearing on a hearings official decision to deny a forest template dwelling in the F2 zone. The criteria that apply to this determination are found at Lane Code 14.603. The subject property is identified as map and tax lot number 160227 0001506. Generally speaking, the property is northwest of Marcola Road and south of McGowan Creek Road. The merits of the application do not apply to the determination to elect whether or not to conduct an on-the-record hearing. However, I will be providing you with some background information about the application and also the property to the extent that it's helpful for an understanding of the appeal issues and also the determination of whether or not to elect to conduct an on-the-record hearing. I'll describe the appeal issues and the planning director's analysis of the elect to hear criteria, and to provide you with a summary of what our recommendation will be. The applicant has requested, and the planning director will recommend that the board elect to conduct an on-the-record hearing. This recommendation is based on the potential discrepancy between the county's past practice of recognizing remnant parcels through the legal lot verification application and the hearings official decision that determined that the validation of unit of land process is the sole remedy to recognize unlawfully created parcels. That said, the board could elect to not hear the appeal if they so chose. To provide you with some background information on the application, a special use permit for a dwelling in the F2 zone pursuant to Lane Code 16.2115, commonly known as a template dwelling, requires that the subject property be lawfully created. The planning director and hearings officials' decisions found that this criterion was not satisfied. The basis for that finding is while the subject property had been evaluated through a preliminary legal lot verification in 2003, it had not yet been noticed in accordance with Lane Code 13020 and therefore is not yet a final or verified legal lot. Conceivably, notice could have been provided concurrent with the template dwelling application. However, both the planning director and hearings official found that the subject property's creation was inconsistent with the 2011 Court of Appeals opinion, Redco versus Polk County, that found that a partition plat that creates a new parcel without depicting any nested lot lines has the effect of vacating underlying pre-existing lots. To provide you with some background information about the subject property, in 1919, there was a 40-foot wide logging road that was conveyed as an exception to a larger piece of property located north and south of what is now McGowan Creek Road. It bisected the property in the northeastern site corner. In 1960, this area was conveyed along with additional area and the 40-foot wide abandoned logging road into common ownership. And then in 1984, a minor partition, M1159-84, was approved and recorded that divided this land into two parcels, Parcel 1 and Parcel 2, and the partition map that was recorded did not continue to depict the 40-foot wide logging road. Then in 2001, there was a preliminary legal lot determination issued that recognized after the partition the abandoned logging road, and it also, there was two separate preliminary legal lot determinations that recognized the area to the north of that and the south of that within Parcel 2. Then in 2003, there was lot line adjustments that reconfigured those three areas and increased the size of the abandoned logging road. And there was a 2003 preliminary legal lot determination that recognized the subject property as a preliminary legal lot. Also, in 2017, during the course of the proceedings of this appeal, the applicant filed, or the owner to the north filed a validation of unit of land application, and that was approved and recorded for the property to the north, tax lot 1508. To give you a summary of the appeal issues, generally the appeal asserts that Redco did not take into account the distinct sequence of events in this application, and that the Redco opinion applied to the elimination of subdivision lot lines, whereas in this case the abandoned logging road was an underlying deeded property, and that Redco should not be applied in a broad manner. That the ambiguities of the legal lot determination form were not fully addressed in the hearings official's decision, that the hearings official erred in his conclusion that the validation of unit of land plat to the north did not have the effect of verifying as a legal lot adjacent remnants. And that the hearings official and planning director's interpretations are inconsistent because while the hearings official indicates the validation of unit of land process in ORS 92.176 is a sole remedy for recognition of an unlawfully created parcel, the county has in the past recognized such remnants through legal lot verification applications. The hearings official has reviewed the appeal and affirmed his decision and determined to not reconsider the decision. And his decision provides interpretations of the applicability of REDCO and other applicable case law, and also the legal lot verification form should these issues rise again. However, the applicability of REDCO and the potential discrepancy between the county's past practice of recognizing remnant parcels and the hearings official decision could affect properties throughout the county and thus be of countywide significance. And it could also recur with frequency, and therefore the planning director finds that the criteria for an on-the-record hearing are met. We do believe that this application will likely be appealed to the Land Use Board of Appeals, and issues in the appeal generally concern state law or the application of state law, and therefore the county will likely not have deference on these issues or interpretation thereof on an appeal to LUBA. However, an on-the-record hearing would allow the board another opportunity to ensure that the county's decision fulfills its legal obligations under ORS 92. And that, for that reason, the planning director does recommend an on-the-record hearing to occur on September 26. 3 orders have been presented. The first one that reflects the board, if the board elected to adopt the hearings official decision and interpretations therein, and elect not to hold an on-the-record hearing. The second recommended an on-the-record hearing of September 12th. However, that date has since been, or the recommendation for the on-the-record hearing date has been revised, and that's reflected in the third order, 1708-2209. And that is the recommended order. That concludes my presentation, but we're available to answer any questions you might have.
Okay, so really the 2 orders we would consider are 07 and 09. 08 is kind of a null and void because of an incorrect date. Okay, excellent. And you're recommending that we consider 09 for a number of reasons, part of which is the applicability of RECO versus Polk County, and part of which is Lane County's practice, historical practice of ruling in a different direction, RECO versus Polk County. Very good. Any discussion to the motion, to the presentation? Commissioner Bozovich.
So staff is recommending that we elect to hear. Has the applicant or the appellant indicated their desire whether they want this to be heard at the county level, whether they want this to move on to LUBA?
Both the applicant and appellant are one and the same, and they have requested that the board elect to hear on the record.
And they've excuse me, paid that additional fee for a board hearing. If this board decides not to give the hearing and simply affirm the hearings official's decision, they would get, the applicant would get a reimbursement for a good chunk of the application fee, the appeal fee.
Okay. Very good. And then September 12th obviously is out for the hearing, but sometime late in September, perhaps?
September 28th.
September 26th is the recommended
26th
date.
is the recommended date. Okay. Very good. Further discussion? Commissioner Williams.
I believe I may have to disclose an ex parte on this in that I received a phone call from Mr. Walcott. He left a phone message for me, and he simply stated, please call me. He didn't stipulate what the reason for that call was, the nature, so I did call him. He had mentioned that he was having some difficulty. It was a little bit confusing to me because he had mentioned Land Watch and he had mentioned some other things that I don't specifically recall. But he, at one point, mentioned something about an appeal, and so at that time I terminated that phone call and then gave the message to County Council. Several days later, that was followed up by a written letter from another party I'm believing it was Peterson, but I'm not sure, which before I received a photostatic copy, and then I received a sealed copy in an envelope, which I gave to county council to declare that, what I've just declared to you folks. So I can tell you none of that has created any kind of a bias in any way, shape, or form. And so I just wanted to share that with you all.
Thank you for that disclosure. Mr. Clark, I don't believe ex parte contact is required at this point. Is that correct?
It does make sense. There are two decisions potentially for the board to make. The first one is whether to conduct an on-the-record hearing, and Mr. Williams' disclosure, I think, is warranted for that. And I think what he said satisfies his obligations regarding this board's decision of whether or not to conduct the hearing. When and if there is a hearing, again, the same sort of disclosure will be necessary to make sure there's no bias in any decision makers for that ultimate decision.
But at this point in time, I do not need to request board to declare any ex parte contact.
Well, I would think to be cautious, given the nature of the applicant's activities to contact board members, it would make sense with respect to the board's decision today whether or not to conduct a hearing for that fact.
So you would recommend to me then that I ask each board member for a declaration of ex parte
I think it would be
contact?
safe, yes.
Okay. Very good. Then we'll go from left to right. Commissioner Sorensen.
I'm on the right side.
The audience are.
Are we on stage or in Congress?
I have no ex parte contact.
Commissioner Bozevich.
No ex parte contacts.
Commissioner Lycan.
The only thing I've had no ex parte contact, but I've had several correspondences from Senator Beyer, Representative Lively, Mayor Lumberg, and several other folks who have sent me the same letter I think that they originally received and received it as well. And my only correspondence has been back to Representative Lively and Senator Beyer stating that we will be hearing this on August 22nd. And at that point in time, so I have not had contact with the folks that are here before us at all.
Thank you. I have had no ex parte contact with the applicant. However, I did speak about this particular item with a former colleague of mine, Larry Campbell, briefly. One time in person, one time on the phone.
Yeah, as long as none of the board members has any bias or preconceived decisions about whether to conduct a hearing, I think we're fine.
Used to have National Guard drills up there, but a long time ago.
The contact sort of, and I guess the reason I suggest we do the ex parte bit now is because there's been a number of contacts encouraging the board to do something to fix the problem that applicant has had, and what the board can do or not is conduct the sort of hearing that is recommended by the Planning Commission. In that regard, it makes sense to disclose what the board's disclosed now. So it's and I know a little bit of history of this. It's a frustrating thing for the applicant because the county's position and policies, as they used to be employed, have been switched a little bit as a result of the Court of Appeals decision that Ms. Bell mentioned. And so it smacks of unfairness on applicants somehow to have the goalpost moved, if you will, in the middle of the thing. But part of the problem is the board is sort of subject to what the state law is on this matter, and the interpretation of what the state law is has differed a little bit. And so that's the problem we're faced with now.
Hence a recommendation that we have a on-the-record hearing. Is that correct?
Right, and as the staff and I discussed, what the board will be doing, it's not a matter of county established policy by the board, which normally would be, for example, interpretation of code that this board has adopted would enable the board's decision to have some deference on appeal. This is not a situation like that because it's really state law that this board would be applying and interpreting. But as Ms. Bell mentioned, planning director, hearings official, and this board all have an obligation to apply and interpret state law as best it can. And this affords the board the opportunity to do that, to sort of another check to make sure we're doing it correctly.
Excellent. Okay. Very good. Any further discussion? Then we have before us a choice of three motions. And the board's recommendation is to, excuse me, not the board's recommendation, the staff recommendation is the third of the three options, 700822-09. So, Commissioner Bozievich.
Thank you. So I'd like to move approval of Order 1708-22-09 in the matter of electing whether or not to hear an appeal and electing to hear, and I believe the date is September 26, 2017 at 1:30 time certain.
That's electing to hear.
Yes.
Second.
So, Order 170822-09 with the date of September 26th, moved by Commissioner Bozievich, seconded by Commissioner Lycan. Discussion to the motion. Commissioner Lycan.
Thank you, Mr. Chair. So, Andy, this question is for you. So, with the on the record before the board, then this means that if the applicant has retained legal counsel or land use consultants, then they would have the ability to present to the Lane County Board of Commissioners. Is that correct?
That's right. It's an on-the-record hearing, which means the evidence is already in the record. The parties that appear before you have the opportunity to present legal arguments as to how the board ought to rule. That will likely be done by an attorney for the applicant. If there is a opposition party, I think Landwatch is involved in this one, they may as well. So.
Yeah. The reason why I bring that up, because I believe they've retained the services of Tom Lamphere, because I see Tom in the back. And I think many of us, I will just speak for myself, I have great respect for Tom and his background, especially when it comes to county land use. And that's why I think this is important to hear, and it's important to get, because Tom will stay true to the law, and that's what I appreciate. And so I think that's why it's very important for us to hear. But also, it does sound like there's maybe some potential issues here. But like you stated, there's state law, and it's our job to decipher as best as we possibly can within the guidelines of the law. And but I think it's important also to make sure that it's presented to us in what I call a even way among all those. And it's absolutely no disrespect to our staff at all. I think our staff does an excellent job. But so I appreciate that. Thank you.
It's and I'll mention, I think Amber did a very good job in her presentation, in part because it's a very complicated series of legal interpretations involved here, and to try to sum it up as quickly as she did is good work and hard to do. I think you really do need to read through the written materials to to follow it well. But also note, I think Mike Farthing is representing the applicant as well. We've met with both Mike and Tom, and one or both will be presenting, I think, for the applicant. So you'll get a good set of arguments as to how you ought to rule. So
well, we can all count those land use attorneys on one hand that they all, and we know who they are, and Mike's one of them. So so I think that's great. Thank you.
Thank you, Commissioner Lycan. And Amber, you know, you had 45 minutes. You can keep going if you want. Okay, further discussion to the motion. I see no further discussion to the motion. I will call for the vote on Order 1708-22-09. All those in favor, please say aye.
Aye.
Passes unanimously. Thank you very much. And at this point, Board, we have a review of assignments and executive session. I had told Council that executive session would begin sometime around 2:30, so there may be a little bit of a lag in time, Mr. Clark, unless we can get a hold of Mr. Dingle and raise him prior to that.
I will see what I can do and let Ms. Jones know what this.
Very good. Thank you very much. Then moving along, review of assignments.
I don't have any assignments, Mr. Chair. Just the request for work session next week on the board decorum document, and then we also talked about moving the tiny house discussion to the strategic plan. So those were the two things we agreed to.
Excellent. Any corrections or additions? I see none. Then we'll move along to second executive session phase 2, which I will read us into. After I've read us into executive session, I'll sound the gavel. We will reconvene in executive session in the BCC conference room.
Before we move away from assignments, I just want to reiterate, we also have a pending assignment to have legal counsel and H&HS keep working on the camping within the UGB.
Yeah. Yeah, thank you.
So that's on the list.
I think that's already an assignment.
Yeah.
Yes.
So, right.
But we kind of
We'll continue that.
agreed to continue that work, I think,
Yep.
today.
Perfect. Then on the sound of the gavel, we'll recess the regular session and move into executive session. The Board of County Commissioners will meet in executive session to conduct deliberations with persons designated by the governing body to negotiate real property transaction and to consult with counsel concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to ORS 192.6602E and H, which allows the Board of Commissioners to meet in executive session for the purposes listed above. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. We reserve the right to come back out into public session should the need arise. Further business?